I never thought a heated driveway would land me in court, but when you live in a neighborhood controlled by Regina Keller and her power-hungry HOA board, apparently anything is possible. My name is Ethan Anderson, and I moved to Pinewood Estates in Boulder, Colorado 3 years ago after landing a software engineering job at a tech startup downtown. The house was perfect. 4 bedrooms, a 2-car garage, mountain views, and best of all, it was within my budget. Sure, the HOA seemed a bit strict during the home tour, but I figured I could handle following a few rules about lawn maintenance and paint colors. I had no idea what I was getting myself into. The first winter in Colorado hit me hard. I grew up in San Diego, where snow was something you drove 2 hours to see, not something that accumulated on your driveway every other day. That first season, I must have shoveled my driveway 40 times. My back ached constantly, and I was perpetually late to work because I had to wake up an extra hour early just to clear the ice and snow. My elderly neighbor, Bill Thompson, told me about heated driveways after watching me struggle one particularly brutal morning in January. "You know, son," he said, leaning on his own snow shovel, "they make systems that melt the snow automatically. Costs a bit upfront, but my brother-in-law has one in Aspen. Says it changed his life." That conversation stuck with me. I spent the next few months researching heated driveway systems, reading reviews, comparing costs, and consulting with contractors. By the time spring rolled around, I had made my decision. I was going to install a hydronic heated driveway system that would pump warm fluid through tubes beneath the concrete, melting snow and ice on contact. No more shoveling, no more slipping, no more showing up to work with frozen fingers. The installation process was scheduled for late September, giving the contractors enough time to complete everything before the first snowfall. I had pulled all the necessary permits from the city, consulted with 3 different contractors, and chosen the most reputable company in the Denver metro area. The system cost me nearly $18,000, but I considered it an investment in my sanity and safety. That's when Regina Keller entered my life like a freight train with a bad attitude. I was in my front yard on a Saturday morning, discussing the project timeline with the contractor, when a silver Mercedes SUV pulled up to my curb. Out stepped a woman in her late 40s with perfectly highlighted blonde hair, designer sunglasses, and an expression that suggested she had just smelled something unpleasant. "Excuse me," she called out, her voice sharp enough to cut glass. "I'm Regina Keller, president of the Pinewood Estates HOA. What exactly is going on here?" I walked over with a friendly smile, extending my hand. "Hi, I'm Ethan Anderson. I live here. Just planning to install a heated driveway system before winter hits." She ignored my outstretched hand, instead pulling out her phone and typing something rapidly. A heated driveway. I don't recall seeing any architectural modification requests come across my desk. "Architectural modification," I frowned. "It's underground. You won't even see it." "And I have all the city permits." Regina's expression hardened. "City permits are irrelevant. Section 7, Paragraph 3 of the Pinewood Estates HOA covenant clearly states that any modifications to the exterior of your property, visible or otherwise, require board approval. You should have received a copy when you closed on the house." I vaguely remembered a thick packet of HOA documents that my real estate agent had glossed over during closing. I had skimmed them, but honestly hadn't paid much attention. "But it's just a heating system under my driveway. It doesn't change how anything looks. The process requires approval," she snapped. "I suggest you submit the proper paperwork before proceeding. Good day." She turned on her heel and climbed back into her Mercedes, leaving me standing there with my mouth open. The contractor, a friendly guy named Mike, shook his head sympathetically. HOAs can be tough, he said. I've dealt with them before. Usually it's just a formality. Submit the paperwork, wait for approval, and we'll get started. I followed his advice, spending that evening filling out a ridiculously detailed architectural review request form. I had to include diagrams, material specifications, color samples, even though the concrete would look exactly the same as my current driveway. I attached photos, contractor information, and a letter explaining the safety and practical benefits of the system. I submitted everything online through the HOA portal and via email to Regina directly. 2 weeks passed with no response. I sent a follow-up email. Nothing. I called the HOA office number listed on the website and left 3 voicemails. Silence. Finally, I received a letter in the mail. It was from the Pinewood Estates HOA board, signed by Regina Keller, and it was a denial. The reasoning was absurd. According to the letter, heated driveways constituted an unnecessary luxury modification that could set a precedent for other homeowners to make similar requests. The board claimed that allowing such installations would create aesthetic inconsistency in the neighborhood, despite the fact that the system was completely invisible. They also cited concerns about increased energy consumption and potential damage to underground utilities, neither of which made any sense given that I had utility clearance, and the system was designed by licensed professionals. I was furious. I had spent months planning this, invested time and money into permits and consultations, and now I was being blocked by an HOA board that seemed to be making up reasons on the fly. I decided to attend the next HOA board meeting, which was held on the 3rd Tuesday of every month in the community clubhouse. When I arrived at 6:30 in the evening, about 15 other homeowners were scattered around the room, most of them looking either bored or resigned. Regina sat at a table at the front of the room with 4 other board members, shuffling papers and looking self-important. The meeting started with mundane business, approving the minutes from the last meeting, discussing landscaping contracts for the common areas, debating the color of the new mailbox posts. Finally, during the open forum section, I raised my hand. Yes. Regina looked at me with thinly veiled annoyance. I stood up. I'm Ethan Anderson from Bluebird Lane. I wanted to discuss the denial of my heated driveway request. I've reviewed the covenant, and I don't see any provision that specifically prohibits this type of installation. It's a safety feature that doesn't affect the appearance of my property or anyone else's. Regina didn't even look up from her papers. Your request was denied based on the reasoning outlined in the letter you received. The board has made its decision. But the reasoning doesn't make sense, I pressed. You mentioned aesthetic inconsistency, but the system is underground. You mentioned utility concerns, but I have clearance. Can you explain specifically which section of the covenant I would be violating? A murmur went through the small crowd. I could see a few other homeowners nodding. Regina's face flushed. The board has broad discretion to maintain the standards and appearance of this community. We don't have to justify our decisions to individual homeowners. If you have a problem with the ruling, you can file a formal appeal, but I assure you the outcome will be the same. Another board member, a thin man in his 60s named Paul, leaned forward. Mrs. Keller, perhaps we could reconsider. The young man makes valid points. The decision stands, Regina said coldly, cutting him off. Next item on the agenda. I sat down, my jaw clenched. Several homeowners gave me sympathetic looks as the meeting droned on. After it ended, Paul approached me in the parking lot. Don't take it personally, he said quietly. Regina runs this board like her personal fiefdom. She's turned down dozens of reasonable requests over the years. Pool installations, solar panels, fence modifications. If she doesn't like something, it doesn't get approved. That's insane, I said. There has to be a way to appeal this. Technically, yes, but the appeals go to the same board that made the initial decision. It's a rigged system. He glanced around nervously, as if worried Regina might overhear. Some of us on the board have tried to push back, but she always gets her way. She threatens legal action, claims we're not upholding our fiduciary duties. It's exhausting. I went home that night feeling defeated but not ready to give up. I spent the next several days researching Colorado HOA law, reading through forums, and even consulting with a real estate attorney. The consultation cost me $200, but it was worth it. The attorney, a sharp woman named Jennifer Martinez, reviewed all my documents and the HOA covenant. "You have a case," she told me. "The HOA's reasoning is weak, and Colorado law requires HOAs to act reasonably. Denying an underground heating system that doesn't violate any specific covenant provision could be seen as arbitrary and capricious. You could sue, but that's expensive and time-consuming. I'd recommend trying the formal appeal process first and make sure to document everything." I filed a formal appeal, citing specific sections of Colorado HOA law and pointing out the inconsistencies in the board's reasoning. I noted that other homeowners had been approved for various modifications that were far more visible than my heated driveway would be. I requested a hearing where I could present my case in person. 3 weeks later, I received another denial. This one was even shorter than the first, basically stating that the board had reviewed my appeal and found no reason to change their decision. I was out of options except for litigation, which could take years and cost tens of thousands of dollars. Winter was approaching fast, and I faced another season of back-breaking shoveling. I felt helpless and angry, but mostly I just felt trapped. October turned into November, and the first snow came early that year. I was out at 6 in the morning, scraping ice off my driveway before work, when Regina drove by in her Mercedes. She slowed down, lowered her window, and actually waved at me with a smug smile on her face. I nearly threw my shovel at her car. The winter was brutal. We got hammered with snowstorm after snowstorm, and I spent hours every week clearing my driveway. My frustration grew with every shovelful. I looked into moving, but selling a house in an HOA-controlled neighborhood was complicated, and I would likely take a financial hit. I felt stuck in a nightmare where a petty tyrant controlled my life. Then, in early January, something interesting happened. I was working from home one afternoon when I heard a commotion outside. I looked out my window and saw Regina's Mercedes parked at an odd angle on the street, and Regina herself standing on my sidewalk, looking down at the ground with a twisted expression of pain on her face. I grabbed my jacket and rushed outside. "Are you okay?" She looked up at me, her face pale. "I slipped on your sidewalk. It's covered in ice. This is completely unacceptable." I looked down. My sidewalk did have a thin layer of ice on it. We had gotten freezing rain the night before, and I hadn't had a chance to salt it yet. But so did everyone else's sidewalk on the street. "Are you hurt?" I asked, genuinely concerned despite my dislike for the woman. "My ankle," she hissed, trying to put weight on her left foot and wincing. "This is your responsibility. Homeowners are required to maintain safe walkways." "Let me help you to your car," I offered, reaching out to support her arm. She jerked away from me. "Don't touch me. This is going to be reported to the board and you'll be facing fines. You're creating a safety hazard." She limped back to her Mercedes, pulled herself into the driver's seat, and drove off. I stood there in disbelief, watching her tail lights disappear around the corner. The irony wasn't lost on me. I had tried to install a system that would eliminate ice from my property entirely, and she had blocked it. Now she was threatening me because of ice. I went inside and immediately sent an email to the HOA board, documenting the incident and noting that I had tried to install a heated driveway specifically to prevent icy conditions, but my request had been denied. I also went outside and salted my entire driveway and sidewalk, taking photos for my records. 2 days later, I received a violation notice. According to the letter, I was being fined $100 for failure to maintain a safe pedestrian walkway in accordance with community standards. The notice included a photo of my icy sidewalk, clearly taken by Regina before she had knocked on my door. I was beyond angry now. I immediately responded in writing, pointing out that the icy conditions had been caused by freezing rain and that I had salted the walkway as soon as possible. I also reminded the board that I had attempted to install a permanent solution to prevent ice accumulation, but had been denied. The fine stood. I paid it under protest, but I also started documenting everything. I took photos of every icy sidewalk in the neighborhood. I noted which homeowners failed to shovel their driveways promptly. I wanted to see if Regina would enforce the rules fairly or if she was specifically targeting me. The answer became clear quickly. Other homeowners with icy sidewalks received no violation notices. One house 3 doors down from me didn't shovel their driveway for 4 days after a major snowstorm, and nothing happened. Regina was singling me out. In late February, I received a certified letter that made my blood run cold. It was from a law firm representing Regina Keller personally, not the HOA. The letter claimed that Regina had suffered a serious ankle injury when she slipped on my negligently maintained sidewalk in January. She was seeking damages for medical expenses, pain and suffering, and lost wages. The demand was for $15,000. I couldn't believe what I was reading. She had slipped on my sidewalk during freezing rain, the same conditions affecting every property in the neighborhood, and now she was personally suing me for $15,000. After she had blocked my attempt to install a system that would have prevented the very ice she had slipped on, I called Jennifer Martinez, the attorney I had consulted before, and scheduled an emergency appointment. When I showed her the demand letter, she actually laughed. "This is one of the most ridiculous personal injury claims I've ever seen," she said. "She's the HOA president who denied your heated driveway request, and now she's suing you because she slipped on ice that you could have prevented if she hadn't denied your request." That's not just ironic, that's legally problematic for her case. "So I don't have to worry?" I asked hopefully. "Oh, you still need to defend yourself," Jennifer said. "She's clearly going forward with this, but we have a very strong defense. We can argue comparative negligence, assumption of risk, and most importantly, we can demonstrate that she directly contributed to the dangerous condition by preventing you from installing a safety feature. That last part is particularly damaging to her case. What do I need to do?" "First, don't pay the demand. Second, gather all your documentation, the heated driveway request, the denial letters, emails, HOA meeting minutes, everything. Third, be prepared for this to go to court. She's not going to back down easily." I left her office with a mixture of dread and determination. If Regina wanted a legal fight, I would give her one. Over the next 2 months, I worked closely with Jennifer to prepare my defense. We subpoenaed HOA records, including all my correspondence about the heated driveway. We gathered weather reports from the day of the incident, showing that freezing rain had affected the entire Boulder area. We took photographs and measurements of my sidewalk. We even got statements from neighbors about the ice conditions that day and about Regina's management style. One neighbor, Bill Thompson, the elderly man who had first told me about heated driveways, was particularly helpful. He gave a written statement describing how Regina had denied his request to install a wheelchair ramp for his wife 2 years earlier, forcing them to use a temporary wooden ramp that didn't meet safety codes. Another neighbor, Susan Martinez, described how Regina had fined her 3 times in 1 month for minor landscaping violations while ignoring identical violations at properties owned by her friends. The picture that emerged was of an HOA president who ruled through intimidation and applied rules inconsistently based on personal preferences. This pattern of behavior would be crucial to my defense. In April, we received notice that Regina had filed a formal lawsuit in Boulder County District Court. The complaint alleged that I had been negligent in maintaining my property, that I had created a dangerous condition, and that her injuries were a direct result of my failure to properly de-ice my sidewalk. She claimed her ankle injury had required surgery, physical therapy, and had caused her significant pain and suffering. Her damages had increased to $30,000. Jennifer filed a comprehensive answer and affirmative defenses. We denied all allegations of negligence and asserted multiple defenses, including comparative negligence, assumption of risk, and a novel argument that Regina had contributed to the dangerous condition by unreasonably denying my attempt to install a permanent ice prevention system. The discovery phase was intense. Both sides exchanged documents and we sat for depositions. Regina's deposition was particularly revealing. Jennifer questioned her extensively about the heated driveway denial. Mrs. Keller, can you explain why you denied Mr. Anderson's request to install a heated driveway system? Jennifer asked. Regina shifted uncomfortably in her chair. It was a luxury modification that didn't meet community standards. What specific community standards did it violate? It would have set a precedent for other homeowners to make similar requests. But isn't preventing ice accumulation a safety feature rather than a luxury? It's still a modification that required board approval, which was denied. Did the board consider that denying this request might actually create safety hazards by forcing Mr. Anderson to rely on manual ice removal? That's not the board's concern. Homeowners are responsible for maintaining their properties. So you expect homeowners to manually remove ice, but you denied Mr. Anderson the ability to install a system that would remove ice automatically. Regina's attorney objected, but the point was made. The deposition transcript would be powerful evidence. My deposition was straightforward. I explained my attempts to install the heated driveway, the denial process, and the events of the day Regina slipped. I remained calm and factual, exactly as Jennifer had coached me. As spring turned into summer, we prepared for trial. Jennifer estimated that court costs, expert witness fees, and her legal fees would run me about $12,000 even if we won. It was money I hadn't planned to spend, but I was determined to fight this injustice. The trial was scheduled for late August. As the date approached, I grew increasingly nervous. I had never been involved in a lawsuit before, and the thought of testifying in court made my stomach churn. The first day of trial arrived on a hot Tuesday morning. Boulder County District Court was an imposing building downtown, and I felt small walking into the courtroom. Judge Patricia Morrison presided, a stern-looking woman in her early 60s with gray hair and sharp eyes. Regina's attorney, a slick personal injury lawyer named David Brennan, gave an opening statement that painted me as a negligent homeowner who had callously ignored basic safety measures, resulting in his client's serious injury. He held up photos of Regina's swollen ankle, medical records, and a timeline of her extensive treatment. Jennifer's opening statement was surgical. She acknowledged that Regina had slipped on my sidewalk, but argued that I had not been negligent. She previewed our evidence about the weather conditions, my reasonable response to those conditions, and most importantly, Regina's denial of my heated driveway request. "Ladies and gentlemen of the jury," Jennifer said, addressing the six-person civil jury, "the evidence will show that Mrs. Keller is trying to hold Mr. Anderson responsible for a condition that she herself prevented him from fixing. Mr. Anderson tried to install a heated driveway system that would have eliminated the very ice that Mrs. Keller slipped on. She, in her capacity as HOA president, denied that request for arbitrary and unreasonable reasons. She cannot now claim that Mr. Anderson was negligent when she directly prevented him from implementing a permanent safety solution. The trial proceeded with witness testimony. Regina was the first witness. She described slipping on my sidewalk in dramatic detail, her voice trembling as she recounted the pain and the lengthy recovery process. She brought in her doctor, an orthopedic surgeon who testified about her ankle fracture and the surgical procedure he had performed. On cross-examination, Jennifer was methodical. She got Regina to admit that freezing rain had affected the entire neighborhood that day. She got her to admit that she had been walking around the neighborhood inspecting properties when she slipped. Most importantly, she got Regina to admit that she had personally denied my heated driveway request. "Mrs. Keller, you testified that Mr. Anderson was negligent in maintaining his sidewalk, correct?" "Yes, it was covered in ice." "And ice is dangerous, correct?" "Obviously." "Mr. Anderson requested permission to install a heated driveway system that would prevent ice from forming, didn't he?" Regina hesitated. "Yes, but that's irrelevant." "Is it? Didn't you deny that request?" "The board denied it based on community standards." "So Mr. Anderson tried to install a permanent solution to prevent ice, a solution that would have protected you and everyone else who walked on his property, and you denied it. The request didn't meet the criteria." "What criteria specifically?" Regina struggled to articulate a clear answer, falling back on vague references to community standards and board discretion. Jennifer let her flounder before moving on. "I testified next, walking the jury through my entire experience. Moving to Colorado, struggling with the harsh winters, researching heated driveways, submitting the request, being denied, appealing, being denied again, and then receiving a violation notice after Regina slipped. I explained how I had taken photos of other icy sidewalks that day and how no other homeowners had been cited. Regina's attorney tried to rattle me on cross-examination, suggesting that I had been negligent and that I was using the heated driveway issue as an excuse. But I stayed calm and stuck to the facts. "Mr. Anderson, regardless of the HOA's decision, you still had a responsibility to maintain your sidewalk, didn't you?" "Yes, and I did. I salted it as soon as I could after the freezing rain. The conditions were identical throughout the neighborhood." "But Mrs. Keller slipped on your property." "She could have slipped on any property that day. The entire neighborhood was affected by the freezing rain. I did exactly what every other homeowner did. I salted and shoveled when I could." Jennifer called several expert witnesses. A meteorologist testified about the weather conditions on the day of the incident, confirming that freezing rain had made surfaces throughout Boulder hazardous. A snow removal expert testified that manual ice removal methods have limitations and that heated driveway systems are recognized safety features in cold climates. An HOA law expert testified that Regina's denial of my heated driveway request appeared to be arbitrary and inconsistent with reasonable HOA governance. We also called Paul, the board member who had sympathized with me at the meeting. He testified reluctantly, clearly uncomfortable going against Regina, but his testimony was damning. He described how Regina dominated the board, made decisions unilaterally, and often denied reasonable requests without proper justification. In my opinion, Paul said, Mr. Anderson's heated driveway request should have been approved. There was no valid reason to deny it. It was underground, wouldn't have affected anyone else, and would have improved safety. But Mrs. Keller didn't like it, so it didn't happen. Regina's face turned red as Paul testified. Her attorney objected repeatedly, but Judge Morrison allowed the testimony. The trial lasted 4 days. Closing arguments were scheduled for Friday afternoon. Regina's attorney argued that regardless of the HOA dispute, I had a legal duty to maintain a safe sidewalk and had failed to do so. He asked the jury to award his client $30,000 in damages. Jennifer's closing argument was passionate and precise. She walked the jury through the timeline, emphasizing how I had tried to be proactive about safety only to be blocked by Regina. She argued that Regina had assumed the risk by walking around the neighborhood during freezing rain. She argued comparative negligence, noting that Regina could have been more careful where she stepped. But most powerfully, she argued that Regina had contributed to the dangerous condition. Mrs. Keller is asking you to hold Mr. Anderson responsible for ice on his sidewalk, Jennifer told the jury. But she is the person who prevented him from installing a system that would have eliminated that ice. She can't have it both ways. She can't block a safety improvement and then sue when the absence of that safety improvement contributes to an accident. That's not justice. That's hypocrisy. The jury deliberated for 3 hours. When they returned, the foreperson announced that they had reached a verdict. My heart pounded as the clerk read the decision. The jury found that I had not been negligent. They ruled in my favor on all counts. Regina would receive nothing. I almost collapsed with relief. Jennifer squeezed my shoulder, a rare smile on her professional face. Across the courtroom, Regina sat rigid, her face a mask of fury. But the verdict wasn't the end. After the jury was dismissed, Judge Morrison addressed both parties. "I'm troubled by what I've heard in this trial," she said, looking directly at Regina. "Mrs. Keller, your conduct as HOA president appears to have been arbitrary and vindictive. You denied a reasonable safety improvement and then attempted to profit from the consequences of that denial. While this is a civil matter, I'm ordering you to pay Mr. Anderson's legal fees and costs under Colorado's frivolous lawsuit statute. This case should never have been filed." Regina's attorney started to object, but Judge Morrison cut him off. "My ruling stands. Additionally, I'm referring this matter to the Colorado HOA Regulatory Office for review of your conduct as HOA president." Regina stood up abruptly and stormed out of the courtroom, her attorney scrambling to follow her. I sat there, overwhelmed. I had won. Not only had the jury ruled in my favor, but the judge had awarded me my legal fees. The nightmare was finally over, or so I thought. 2 weeks after the trial, I received a notification that Regina had filed an appeal. Jennifer assured me it was a long shot and unlikely to succeed, but it meant more legal limbo, more stress, more waiting. Then things got interesting. In early September, I received a letter from the Colorado HOA Regulatory Office. They had investigated Regina's conduct as HOA president based on Judge Morrison's referral, and had found multiple violations of Colorado HOA law. The letter detailed findings that Regina had exceeded her authority, applied rules inconsistently, denied reasonable requests without proper justification, and used her position for personal benefit. The regulatory office was imposing fines on the Pinewood Estates HOA and had recommended that the homeowners vote to remove Regina from the board. I shared the letter with Bill Thompson and several other neighbors. Word spread quickly through the neighborhood. A group of fed-up homeowners organized a special meeting to call for Regina's removal. The meeting was scheduled for late September, and I made sure to attend. The community clubhouse was packed. At least 60 homeowners showed up, far more than the usual handful who attended monthly meetings. Regina sat at the board table, looking defiant and cornered. The meeting was heated. Homeowner after homeowner stood up and shared stories of Regina's tyrannical behavior. One couple described how she had fined them for having a vegetable garden in their backyard, claiming it violated landscaping standards, even though it wasn't visible from the street. Another homeowner described how Regina had denied their request to install solar panels, citing aesthetic concerns, only to approve solar panels for her friend's house 3 months later. When it came time for the vote, the result was overwhelming. 87% of homeowners present voted to remove Regina from the board immediately. She was also removed as HOA president. The board would hold new elections within 30 days. Regina stood up, her face flushed with anger and humiliation. "You're all making a huge mistake," she said, her voice shaking. "This neighborhood will fall apart without proper leadership. You'll see." She grabbed her purse and walked out, slamming the door behind her. The room erupted in applause. Paul was appointed interim president, and the board immediately began reviewing Regina's past decisions. Over the next few weeks, they reversed several of her arbitrary denials, including my heated driveway request. In October, I finally got to install my heated driveway system. The same contractor I had consulted over a year earlier came out and completed the work. The installation took 2 weeks, and the system was operational just before the first snowfall of the season. That winter, while my neighbors scraped ice and shoveled snow, my driveway remained clear and dry. The system worked perfectly, melting snow as it fell and preventing ice from forming. It was glorious. I never had to shovel again. Regina's appeal was denied in November. The appellate court affirmed the trial court's verdict and the fee award. Regina ended up paying nearly $14,000 to cover my legal expenses. I also learned through the neighborhood grapevine that Regina and her husband had decided to sell their house and move. They listed the property in December and closed in February. I never saw her again. The new HOA board, elected in November, was much more reasonable. They revised the architectural review process to be more transparent and less arbitrary. They created clear criteria for evaluating modification requests and established an independent review committee for appeals. Paul was elected president officially, and he did an excellent job balancing reasonable community standards with homeowner rights. In January, a year after Regina had slipped on my sidewalk, I stood in my kitchen drinking coffee and watching snow fall outside. My heated driveway was doing its job perfectly, the concrete bare and dry while snow accumulated everywhere else. My neighbors walked by, many of them waving and giving me thumbs up. A few had even submitted their own heated driveway requests, which the new board had approved. I thought about everything that had happened: the initial denial, the frustration, the violation notice, the lawsuit, the trial, and finally vindication. It had been exhausting and expensive even with the fee award, but I had stood up to a bully and won. More importantly, I had helped change the culture of an entire neighborhood. My phone buzzed with a text from Bill Thompson. "Thank you for fighting back. This neighborhood is finally a community again." I smiled and texted back, "Thank you for the support. Couldn't have done it without everyone standing together." That was the truth. Individual homeowners couldn't fight HOA tyranny alone, but when a community came together, change was possible. I finished my coffee and headed to work, my car sitting in a perfectly clear, dry driveway. No ice. No snow. No problems. The HOA battle was over and I had won.